Welcome back to the Southern Scene. It's time now for our legal scene. You know, the past 20 years, we've kind of seen a medical revolution in America. Pharmaceutical companies, as you know, manufacture, test, and introduce new drugs regularly. But despite all the testing by the drug companies and monitoring by the FDA, lawsuits are an inevitable side effect of new drugs on the market. And that's what we're talking to our legal expert, Mark Tate of Tate Law Group, about today, the pharmaceutical industry. Mark, I want to ask you about Accutane. I mean, a lot of people have taken Accutane, specifically young people. What's the latest on that?
Yeah, Accutane is a drug, and it is a dangerous drug, and there are cases that are going to trial. Accutane is no longer made by its original manufacturer because they lost the patent on it. It's now only generic, and that causes a number of problems. And we have a number of Accutane cases that are filed, and Accutane causes inflammatory bowel disorder. And it can really be devastating because what the drug does is it dries you out. It dries out mucous membranes, it dries out other membranous material in your body, and so you know, the digestive tract, the bowel system, is very susceptible to that. And we've seen young men and women who took Accutane to deal with bad skin during their adolescent years, who've developed really bad bowel problems to where some of them even had to have a permanent colostomy. The big problem with the whole situation with Accutane is now it is primarily a generic drug that people are calling us about. If it's a generic drug, you can't sue the manufacturer of the generic. We're working on theories to get around that now. One is that, fine, if the generic's not responsible for it, then we're going to sue the name brand maker even though they don't make it anymore because they're the ones that developed the product. That strategy has not been determined yet to be valid. So we don't know what the Supreme Court of the United States will say about that.
Let me ask you this. I know that a lot of people, they really it's a misconception on who you go after if you've had, issues with a particular drug that you've taken. I mean, is it the doctor? Is it the pharmacist? Is it the drug manufacturer?
Well, this, again, comes, addresses the importance of selecting the right lawyer. Sometimes lawyers will get their hands on these cases and they will want to try to avoid being involved in national litigation, and they will do things that are frankly ill-advised and stupid. One of the things that they will do that I learned 20 years ago didn't work is try to name a local distributor, okay? The local distributor is the guy that we know down the street. He's just a guy that bundles up a product and delivers it to the doctor to use. Other lawyers will do things like sue the doctor. And the doctor frequently can either be your best friend or your worst enemy in a bad drug case. With Wyeth and their drug Fen-Phen that caused primary pulmonary hypertension, the pulmonologists who were treating the people that had this deadly disease were our best friends in proving that that drug caused primary pulmonary hypertension. On a peculiar occasion, there will be a drug that has a specific warning that says, don't take this drug if you are, for example, with Chantix, don't take Chantix if you're psychotic. If a doctor has a psychotic patient that he wants to keep from smoking, if he gives him Chantix and that patient kills himself, then that doctor's going to be responsible for giving a product to a patient that he's told not to. But that's a completely different question.
What about pharmaceutical companies? Aren't they used to going up against and fighting lawsuits and they're kind of masters at it?
Oh yeah, they're extraordinarily skilled at doing that. And they start from years before the product even comes on the market, and they start researching and they start creating their own research by hiring doctors to come up with answers to questions, and they will actually and have been shown to create a disease and say, okay, now we have this disease called social anxiety disorder, SAD, right? And so, okay, everybody sometimes gets sad, and so we're going to create a drug to treat you if you're sad. And it turns out that this drug will tear you up worse than having social anxiety disorder. So they've identified a disease, and they have said it exists. They get it put into a diagnostic statistical manual, and now they create the drug to treat the disease that is really not even there, and they create the research to show that their stupid drug treats this stupid disease they made up. And so they build the research, they have the experts, they have the professionals, they've got the money. And so really, when we take on these cases and we take them on a contingent fee, meaning we don't get paid unless we win, you know, it's a huge roll of the dice. You don't know what's going to happen.
But you can win, and Tate Law Group has won.
Yeah, we don't lose our mass tort cases.
All right, thanks a lot, Mark, for joining us. If you'd like more information on this issue, or you have a specific legal question you would like to ask Mark, all you have to do is send us a message on our Facebook page, The Southern Scene, or go to our website page, WSAV.com. We'll get all of your legal questions answered for you. Don't go away. We'll be back with our entertainment scene right after this. Stay with us.